that's good. All right, well, let's.
We put up the pop-up check if that occurs.
Yeah, there should be good. Okay, so we'll just go ahead and talk through this. If everyone, don't feel free to take yourself off mute. This can be a discussion as opposed to, just a lecture. This is me. I am an attorney and obviously CISSP. Most of my it's becoming less and less most, but for the first 8 years or so, I was in the high tech unit at the Consumer Protection Division of the Washington State AG's office. And I did a lot of enforcement investigations. Washington has what's called a Baby FTC Act, which means basically that it's the same language as the Federal Trade Commission Act. So everything that the FTC can do, more or less, Washington can do as well. Hey, there's Joe. Since then, for about 5.5 years, I have been focused on, broadly speaking, technology law and litigation. That can involve regulatory defense, more recently, quite a bit of breach and incident response. And what I like to do the most is proactive counseling. So first, let me be very clear, even though this is a nice little small group, and I don't think anyone's going to ask, but I'm not providing legal advice. These are just my opinions. And I am not really sorry that there's a lot of text in this presentation, because it is, I think, useful. And it serves as a good reference if you have questions later on. So I think it's worthwhile to kind of go back in time to 2015. This is taken from a presentation I gave at my first Secure World, actually. May it rest in peace, such as it is. And
I think that was with we did that together, didn't
it? Who, you and me?
Yeah, for Secure World. I mean, if I remember.
I think we did. I could have been. I was still in AAG.
Yeah, I remember that.
Yeah. And so, yeah, I think you were probably there for this one, and this was this was kind of the state of the art in this would have been November of 2015. So we really had the FTC's first case, the Wyndham Worldwide Corporation. I say first case; it was the first case that went to a court of appeals. There have been others since then, including the notorious LabMD case. The lessons of Wyndham were not particularly useful. The FTC has been doing data security and privacy cases for probably, at least 15 years, give or take, but they haven't been very exciting or common until more recently. And the FTC has nice little things like their Start with Security handbook, which for anyone in this group is going to seem really simple, because it is, but it is helpful for businesses, I think, to have that information. The problem with Wyndham is that the security failures were so egregious that you can't really learn much from it. For example, these old slides talked about how Wyndham, which was, in case you don't know, was a hospitality, they're still around. You see it with their Wyndham Resorts, timeshares, all that stuff. But they didn't encrypt their PC. They didn't encrypt their PCI, which Gene, I'm pretty sure, could tell us is not PCI compliant. They had default passwords to management systems. They didn't even bother installing firewalls, let alone configuring anything. They did nothing right. And so while it was a great case for the FTC to establish kind of for once and for all their ability to regulate cybersecurity, it didn't really help move the ball forward in any meaningful way. Also at the time, you can see this was pre-GDPR, pre-CCPA. That all seems like a weird time, plus that it was only 5 years ago. So that's kind of where we were. Things have changed as of today. And, this slide is potentially controversial among certain FTC watchers because it's not immediately clear that the standard still is reasonableness. As a lawyer, I care first about what the law says, then I care about what case law says, and eventually at some point I care about what blog posts and the FTC says in enforcement bulletins or speeches. So right now there's really two sources of FTC law. There's obviously the courts and the decisions that have come down, but the vast majority of it is the consent decrees and the consent orders and the Federal Trade Commission decisions, and those used to say reasonableness, but as we'll learn, they have they got in trouble. The FTC, that is, got in trouble a couple of years ago with the LabMD case, and I'm curious. If we have the ability, people can raise their hand. Raise your hand. I'm not going to ask you to speak, but raise your hand if you don't know anything about LabMD. If you've never heard that case, I just would like to get a sense of who's heard about it or who hasn't. You should be able to do that if you open the participants tab. There should be a button that says raise hand.
Really? I don't see. Oh, wow.
Well, Jeremy did it, so it's there. Okay, so
okay.
All right. So at least a third of the audience has never heard of LabMD. LabMD is they're a company that they had medical information, and they fought the FTC. They didn't accept what the FTC was trying to do, and so ultimately what happened is that it almost doesn't matter what their practices were at the moment, because what happened is that they signed a consent decree, and then they challenged it as being vague. In a sense, what they did was say, look, we don't know what the hell you want us to do. And we think it is so difficult to understand that it is legally insufficient. You can't enforce it. And the court agreed. I want to say it was, again, the Third Circuit, but don't quote me on that. Regardless, the effect was that the FTC revamped its entire consent decree language, and you actually won't find reasonableness in there anymore. That is not to say that reasonableness still isn't the standard, or that you might not, conceive of it in the same way as these 4 check marks. But it is not currently appearing in the consent decrees. The problem, of course, is that you will find reasonableness everywhere else. It is still the kind of primary definition of how to do cybersecurity in at least legal language. And then the statutes have also expanded greatly. Federal law hasn't changed much, although if anyone's been watching the news over the last week, I think it was late last week, the Senate came down with a new data. I think they called it the Safe Data Act, or it had some clever acronym. I wouldn't worry too much about it, because its chance of passage is, as high as any other federal law right now, which is not very high. But it was pretty comprehensive. It was kind of a American GDPR in a sense. Brazil has their own law now. And then states have really expanded. Obviously, you've got CCPA. You have the California Privacy Rights Act, which is on the ballot for just about a month and a few days away. If that passes, it will revamp CCPA again, which will be fun for, at least for me. It won't be fun for everyone who has to deal with it. The New York Shield Act has been around for, I think, since March. It's been around for longer, but it's been enforceable since March. And they all have kind of different types of data security standards, and we're going to kind of go through some of those. So this is a fun little graphic. Just since 2016 to 2018, you can see how many data security related laws have come into being. It's more now. I don't have a nice little graphic for 2020, but there's not that many states left, frankly, where there's not where there's nothing. And so, rapidly we're getting to the point where every state is going to have some form of security statute. So, I think that there is good news. There is a lot more guidance. While there are multiple standards, I still think they remain pretty similar, and I think you're going to see that through our examination of a recent Federal Trade Commission order, the Gramm-Leach-Bliley Act safeguards rule, Article 32 of the GDPR, Shield Act, and CCPA. By the way, I should have mentioned this will really help you with what is that? The first domain of the CISP issues. I mean, you will get more legal out of meetings that I do than you will probably see in the rest of ISC squared. I would defy anyone to argue with me on that. So here is the fun one. This is Lightyear Dealer Technologies. It is, they are a software as a service company that provides essentially customer management and records tools for car dealers. And the really interesting thing about this case is that the FTC managed to squeeze this SaaS provider to car dealerships under the definition of financial institution under the Gramm-Leach-Bliley Act. And you all may be wondering, how is that even remotely possible? You may be freaked out by the fact that one of the commissioner's last names is Slaughter. That might be a valid reason to be afraid. Regardless, what they did is important because they stretched the definition to anytime where there's financial data involved. And of course, this information, or they had all kinds of consumer financial data in there, which is why they were considered a financial institution, even though under any normal definition or concept, no one would ever think of them as anything like a bank. But I think the main reason that they kind of got stuck in there is that they would do credit checks and things like that for help dealerships do financing. So that's kind of how that was the in. Okay, so the 20-year span of the FTC order hasn't changed. They really haven't changed the kind of primary component, which is you're not going to do anything with personal information unless you establish, and this is where it gets new, a comprehensive information security program that protects the security, confidentiality, and integrity of personal information. So far, so good. And here's where it gets really new. Rather than talk about reasonableness, they say at a minimum. At a minimum what? Well, all of these things and more, you have to document the information security program. You have to evaluate that guy every 12 months and give updates. You have to designate a specific owner. That's a best practice, but now it's going to be required under FTC precedent. If you're not doing risk assessments and documenting those at least once a year, you need to do so. I don't think there's I'm not going to go through and read all of these, but I think it is worth noting the level of detail and also the level of, frankly, even continued vagueness that they're going through here. I mean, what does it mean to assess the sufficiency of all safeguards? What are you supposed to do with that? I mean, I think people with CISPs could figure it out, but what if you don't have a CISP on staff? What do you do then?
I recall you doing this presentation once before, and I'm not trying to stop you, but what I had a question is very particular to this is, as this company, why didn't they just declare bankruptcy?
So this,
this particular situation, I mean, when again, I had time to think about it, so I've got a loaded question, but when I was thinking about this, I was like, I mean, if I was the owner, this is a pretty small company, just declare bankruptcy and start over again.
You mean Lightyear Technologies?
Well, because this was very particular to this one particular this company that was selling cars, right? It was a car dealer.
It was actually it was not a car dealer. It was the SaaS provider who had hundreds of car dealerships as clients.
Sure, still declare bankruptcy and start over again.
Well, so the FTC has.
Sorry, I kind of threw you a curveball there, but
no, it's not. It's a fair question. The FTC has ways around that. For one thing, declaring bankruptcy is not as simple as it sounds. It's actually a big deal. It's also not clear that they even were insolvent, and so they could they could potentially close the business down, but more than likely they would have also named or required the owners to sign on to some of these things. So, and actually, the next slide is going to get into kind of that issue even more, which I think you'll find pretty interesting.
So you're saying as an individual contributor, as a CISSP, as an ISC2, or as a CIO, I could be held personally liable now.
That is the direction things are going. Yes, I mean it's not so much it's not so much the security folks, but the officers and directors of companies are under there. That is very much where
Crap goes downhill, man. It's like that's the only
it
problem.
it does. But wait until you see what's coming here. So I mean, all of this stuff is familiar, and I think, Frank, this particular set of slides was I mean, it was somewhat recent on a ISC, or no, it was a Secure World webinar. I don't know how many of you, if any, were on that, but they would look familiar if you had been. But I think here's the interesting part, to go to your question, is this is what they start to require. This is totally new. This was definitely not the case, back in 2015, or really until they started redoing this. And the reason, by the way, this is important is that this isn't. You're right. This is specific to that particular company, but this is the FTC they just reuse the language. So the reason I'm going through this is that this consent decree has become their new standard, which means that all the future consent decrees say the same thing, and they'll just change out the company name. That's how they used to do it before, when they used the reasonableness standard. It's how they're doing it now that they have this at a minimum standard. And there's more than one that you can go find at this point. And what you'll see here is that, if you're under one of these consent decrees or orders, you need to have these biannual assessments, which is, whatever, we can talk about that. It's the annual certification that I think is really different, where a senior corporate officer must certify in writing that they are in compliant with the requirements of their own information security program. And if it's not based on that person's personal knowledge, then it must be based upon personal knowledge of subject matter experts within the company upon whom the officer relies. So I'm curious, in this group, what do you think of this? Do you think this is the reason this is done, by the way, from the FTC's perspective, is that they were tired of issuing these consent orders that were difficult. I mean, accountability, right? IAAA, accountability is always critical. It's critical as part of security. It's just as critical in law enforcement and regulatory enforcement. So that's what they're trying to do. They're trying to hold people accountable for real, instead of a lot of, frankly, paper tiger type orders. Yes, and
I don't know.
I see that
it's like nobody's speaking up, but I'll share with you. It's like
Gene approves.
how why didn't more people from, take a look at some of the large companies that have recently declared thousands of names or thousands of information being disclosed. Do those officers go to jail? I mean, are we seeing literally a stream of people going to jail?
So these aren't jail. So one thing that's important to remember is the FTC does not have any criminal authority.
Fine. I mean, to the point where they're basically being fined to death, right?
Yes, that would be the goal. You don't want to be caught breaking one of these, then they hit you with huge fines. And I think, again, the goal here is we need people to take the requirements seriously. It's interesting timing for this meeting, because over the last 2 days I have been participating in the Sedona Conference Working Group 11, which is all about data security and privacy. And, we could use more practitioners from this group and related in the Sedona Conference, which is primarily lawyers. But the Sedona Conference has some outsized influence, because they write things like the the model data breach notification law, and they write things that courts often cite to. And today I was just arguing literally with a DPA, like the Bavarian data protection authority was on our call. He was on our Zoom meeting, along with the guy who negotiated Privacy Shield, talking about the Schrems 2 ruling, which I don't know if anyone here is familiar with it, but dear God, it has really, it blew up Privacy Shield. So Privacy Shield is dead. And everyone's now responsible for doing case-by-case analyses of the risk to persons' autonomy based upon the national security laws of the third country. And if that sounds insane, it's because it kind of is.
Jake, there's a couple of statements that just as far as the chat's kind of catching stuff, and I wanted to be the voice of chat.
I see the chat. The biennial assessments, yes, they're by a third party. They have to be by a qualified and objective and independent third party. That language is straight out of the new consent orders. So, I think, things are, I would say that, things are really picking up from the legal side in this space. I remember, Frank, you were there at my personal first introduction to security at that very first Secure World. And I knew nothing at all about any of what all of you do until that point. And I think that the number of cybersecurity lawyers doing the law, having practices has exploded in the last few years. And as that happens, more cases get brought. Guess what? Think about if I was a plaintiff's lawyer, how much you would all hate me. And I say that not really joking. I mean, there's going to be those. There's going to be lawyers who do plaintiff's work, who go and read the CISP books and figure this all out and start suing all of our clients and employers. And they're going to be way more effective than has been traditionally the case, because frankly, the lawyers in the past didn't know anything about security or technology, which is different now. So
glad I empowered you to be dangerous, Jake. I really appreciate being called out for that.
Well, no, you didn't invite me. It was I don't know who invited me. It was probably
inspired you, not invited you.
Inspired. Yes, you did inspire. Yes, that is true. Okay, so let me kind of speed through this. I could go on this stuff for hours, as you can probably tell. I think
hey Jake, I just wanted to add that, to me, it just seems like a lot like many other compliance initiatives. But this is obviously more in regards to data privacy, but, I kind of think about PCI compliance. It looks pretty similar.
Well, except PCI is not a law, right?
No, yeah. PCI is not a law, but I studied an awful lot of laws and regulations to try to put stuff together.
It's not that PCI isn't well written, Gene. It's very well written. The problem is that it's still not a law.
It's not comprehensive. It's not a law.
Yeah, it's not a law. Exactly.
No, it was only meant for a certain industry for a certain time.
Right. No, that's a great point.
And Visa is the only one that, I'm air quoting, enforces it.
Exactly. There's a lot of model laws out there with private rights of action. A lot of them struggle mightily to get through the lobbyists. But the CCPA is live, and if anyone gets breached, there is the potential for a $750 per record statutory damages class action in California, which already isn't the state you want to be in to defend a class action.
So it's kind of the concern with these data privacy laws that are coming into play. Is it kind of an overstep? Is that what we're thinking?
That's a matter of policy and opinion. Interestingly enough, for the CCPA, though it is titled the Privacy Act, and though the vast majority of it is about privacy, the cause of action is actually only for the failure of security, which is, I think, super interesting. In other words, if a business fails to honor your opt-out request, or doesn't delete your data, you can fume and you can file a complaint with the AG's office, but that's all you can do. You can sue if they're breached, and the way that they defend that breach is to prove that they had a reasonable cybersecurity program. Hence this presentation. But I think it's a really interesting thing to keep in mind.
Yeah, definitely.
Okay, so I think given what we've been talking about, I'm not going to try to go through every single slide here. The standards for safeguarding customer information under the Gramm-Leach-Bliley Act apply to financial institutions. However, as we just saw, that definition is flexible, if you will, and I think it's a good source of it's an older source, no question, but it's still a good source to get a sense of what these laws are written, or I'm sorry, how they're written. They're more specific than not. I think they're more helpful for that reason. But they're definitely, there's a lot of convergence, and that was
Hey,
go ahead.
Jay,
Yeah.
do you think it's some of the European and the Canadian laws are better written, or more to the point and not as flaky as ours? Because one of the things we noticed when I was looking at a lot of the laws was, of course, at the time, a lot of the laws conflicted with each other, and you had to sit there going, okay, who's the most strict?
Ambiguous for ambiguous sake.
Yeah, I mean, it's really hard to write laws that don't suck, even when you know what you're doing and talking about it. But most of the people who've written these laws were lawyers without security experience, so I'm not surprised. I do think, though, if you look at the New York Shield Act and the slightly older Department of Financial Services cybersecurity rule, also in New York, they just took NIST. They just took the NIST cybersecurity framework and were like, yeah, let's just kind of build a law around these concepts. And I think it's better than some of these older ones. Is it easy to figure out what you're supposed to do? Not really. But I don't think it ever will be. As one of my friends who's written a book likes to say, cyber is a dynamic risk. And because it's a dynamic risk, how you deal with it is not really amenable to, writing it down and having it not change. So here's kind of, I'll make these slides will be available if you want to go back and read about this, but I want to talk quickly about the GDPR because it's a good comparison point. Much like CCPA, the vast majority of GDPR is about privacy and has nothing to do with security. This is Article 32, and it is about all the GDPR says about security. You can see it's got such helpful phrases like taking into account the state of the art and the costs and the nature, scope, context, and purposes of processing, as well as, this is my favorite, the risk of varying likelihood and severity for the rights and freedoms of natural persons. I've been doing this for my entire professional career. I can't really explain to you what that means. Not with any, I could do it philosophically, but not with any concrete way to instruct you on what to do. And that can be very frustrating. This part's easier. The controller and the processor will implement appropriate technical and organizational measures, blah, blah, blah. We've seen all this before. But I think, a lot of security pros in particular will talk about GDPR, probably not realizing that GDPR does not say much in specific about security. This is about it. It's risk-based, which I think is better than having some form of just checklists. I think checklists are, not particularly helpful. I'm going to check the chat real fast here. Yeah, most of your business comes from lawsuits. Interesting. Okay. Yeah, and I think to the extent, I mean, I think the underlying policy issue that we're kind of hinting at in the chat and in this conversation is that, all of us have recognized that security is valuable and important. For a lot of us, it's our careers, or has become our careers. But historically, there's not a single person who's a member of this organization that would say it's been easy to get funding for my security projects over the last decade and a half. I think it's quite the opposite. And I think that the liability and the risk is going to drive this forward in a way that just was never really possible before. It's already happening. And I think a good example of that is another brand new law, which is the SHIELD Act. Yes, it has a clever acronym, but I don't remember what it stands for at this point. But here's your reasonable security requirement. Basically, it's any person or business anywhere in the country, or actually world, really, to keep that in mind, that has the information, the private information of a New York resident. I think it's one thing to keep in mind. It's important to remember about all these state security laws is that they trigger off of their citizens, not where you are, just like the GDPR and CCPA. So in other words, you might think to yourself, I don't need to worry about the SHIELD Act because my business is nicely over here in Washington. But that's not really true. If the business that you work for has the information of a New York resident, this applies. A lot of people, I think, don't understand the lawyers call it the long arm statute, but what it means is the ability of a state court or a state to sue you and bring you into court from across the country. And thanks to the internet, which many of you have been responsible for making possible, there are very few arguments about being unable to make an appearance in court these days, thanks to video calls and video trials even. This is a weird situation. This is a weird circumstance where the law has adopted the technology pretty quick, all in an effort to continue to, move forward and do business, which I think is kind of interesting. The safeguards for the SHIELD Act are, once again, I leave it up to you to decide if these are vague or specific. It's usually a mix of both. I think, A1, that's pretty specific. Someone has to coordinate the security program. 2 is, I think, yes, that's right. Gene found it. It's stop hacks and improve electronic data security. That's SHIELD. And yes, I remember laughing at that as well. Identify reasonably foreseeable internal, external risks. Okay, that sounds good. Like in terms of, it's not totally vague, but what are you supposed to do about them? It doesn't really say that. The next step then is to assess the sufficiency of those. It doesn't really give a recommendation or a requirement for what sufficient is. As a matter of practice, the courts and lawyers and judges are going to look at something like SB 853, which I believe just released its 5th revision. So that's kind of where you would look to figure out safeguards and whether or not they're sufficient. And again, I'm not going to bother to read all this stuff aloud, but I think it's really worthwhile knowing what is expected under some of these laws. As a kind of point of interest, you'll see this is called Spot the Lobbyist, and you can do it in a past law when you find something that's as ridiculous as this. This appears to be, at first glance, a carve-out or a safe harbor for a small business. But if you actually read all of it, you realize that it's the same exact set of requirements. It's just that if you're a small business, you only get this little tiny paragraph to figure out what to do, as opposed to that much more complex set of requirements that we just went through. So I find that kind of funny, but it happens all the time. CCPA, everyone's current favorite.
And with something like that, how is the fiscal responsibility? They picked 5 million as some random value. I mean, how did they actually come up with those thresholds? That's the thing, is, again, as you said, this is not security people or computer related.
This is far worse. This is lobbyists. This is sausage making lobbyists. I mean, who knows? where this definition came from. Sometimes it's reasonably accepted. Sometimes it's like less than 5 million just because.
A lot of it comes from tax code.
Yep, that is all true.
Different sizes of businesses, like Washington does that for, I think Washington has 5 sizes and they're based on the amount of income you have.
Yep. I think, from a security practitioner and practical standpoint, it doesn't matter. In fact, I personally think that all of these all of the standards already take into account. Literally, it says right there, the size of the business. So I don't really know why you needed to have it carved out. I think, like I said, someone did it because it felt good to put in something and they could tell the lobbyists they did something for them. You don't want to know how laws get made. It's bad. Okay, CCPA, speaking of how laws get made. So CCPA is pretty long as statutes go. This is literally everything about security. What I did is I just downloaded the full text of the act and I searched for security. This was the hit. It's basically, even though it's the most important part from a private liability standpoint, they give you basically nothing. So you're going to have to go elsewhere from CCPA in order to figure out what they mean by reasonable security programs, which is fine. It's probably better than yet another list, but I think it's interesting, and I don't believe that this will change if the new California Privacy Rights Act passes. I don't think they messed around with this part. So from a lawyer's perspective, how do you create the reasonable cybersecurity program, and what's the point? Well, I don't have to explain this to this group about how the methodology. The goal, though, when I'm talking to executive leadership, and maybe this will be helpful for some of you, is to create a defensible program. I want it to work. I do. I like the security aspect of it, but if I'm really honest, I just care that I could defend it against a regulator or a plaintiff's lawyer. Hopefully those goals will align. But if you're searching for language to describe the importance of some security initiative, you can consider talking to your colleagues and your executives about, well, look, what if something bad happens and we have to defend this? Can we really defend not using, an IDS or something more modern? What does it look like if we get this nice assessment and then ignore it and it sits on the shelf? That's kind of topics from other talks I've done, but it's really important for this situation. So
Jake, let me introduce kind of a different thing for you to think about is that, the most latest version of NIST now starts to actually call out OT, not just IT. Interestingly enough, most OT environments are really old. When I mean really old, I mean they're like possibly as late as the 90s. And the interesting thing, and everybody hopefully is familiar with OT, operational technology. Think of your heating, your cooling, your electrical, water cleanliness, water sanitation. All of those systems actually run on a computer system of some sort. But interestingly, most of the time they are isolated.
Yep.
That was the protection that these manufacturers introduced I'd say probably in the 90s. I started in that prior to coming over to basically moving over to computer science. I actually was, a physical plant physical plant operations manager. And I had chillers that were connected to computers. And some guy came around who had the bright idea, said, hey, you know what? I don't have to come in at middle of the night to check on the system to make sure it's running. So I'll put a phone on it. Literally, this is in the 90s.
Yep.
Now all of a sudden you could dial in to a chiller, which is a cooling system, and check to see its status. Not only that, but you could actually modify the thresholds.
Yep.
Fundamentally, today now, all of a sudden, as I said, the latest version of NIST now has actually started calling out those particular risks. How do you see? I mean, I have a feeling that most organizations aren't ready to take this problem on.
So actually, I have some surprising news that's actually good in this case. So first of all,
surprise me.
yes. So I haven't heard them called OT. I've usually heard them referred to as like ICS, industrial control systems. Same idea, clearly.
That's the protocol.
But I have a number of clients who do have far more physical assets than cyber assets, and this comes up all the time. And it's what's really interesting, Frank, is that to take your explanation to the next level, ultimately what happened is that those phone lines and those modems became NICs, and they started they just got onto the data network, right? Well, we all know what happens when you put something on a data network, and predictably things have moved back. So what you're seeing now in like the HVAC space, coolers, warehouses, is that they're still connected, but now they get their private cellular network. So it's a private 4G network that they are on, and I think it's better. Definitely better than being on the data network. It does create more complications, of course, because now potentially every piece of equipment is spewing its own radio waves connecting to some LTE tower. But
some of them actually still use VoIP, voice over IP.
Oh yeah, some could. I think
the problem with that is you're familiar with Stuxnet, right?
Yes.
So again, security through obscurity has historically always proved itself. Oh, and just again, if anybody's not familiar, Stuxnet really utilized physical compromise of USB sticks, where physically they were moved into an isolated network, which is kind of what you're talking about, is isolate your CE or your critical environments or your EPMS or whatever happens to be your services. Problem is that these third-party companies are still running software that is painful legacy.
So what it does is it moves the attack surface from you, which you can control to some degree, to third parties who you can't control. So that's and that of course goes to one of my biggest kind of pet projects these days, which is having companies stand up third-party and vendor risk management programs. Frankly, most don't. And that's a big part of it. I think, Frank, you should Google the million chicken deaths that occurred because a hacker went into the warehouse system and increased the temperature, thereby killing 1 million chickens. It was actually a disgruntled former employee. So there's your insider threat, but it's happened. I've read about the distilleries that are highly tuned machines making liquor, but they're also just giant
bullshit on it. It was actually 2 million chickens.
Okay, 2 million chickens. So yeah, that's exactly. So this, it's real. It's been happening, and I think it's in many ways that probably has the greatest opportunity or the greatest chance of kind of being the cyber 9/11 that we've talked about for years. One of my clients deals, has buildings that a bunch of people are going to go into. All kinds of potentially bad things can happen when you have people that you trap in a building and turn off the lights and the water and the air conditioning and all that stuff. So the good news is people are thinking about it. The bad news is I don't know if that's enough. So let's see. I got 2 more slides. I think this is, I left this slide in here primarily because I think it's helpful to let security practitioners know what it is that legal can do, how they can help, and how everything overlaps. And one of the things that you might consider is if your executives won't listen to you, they may listen to a lawyer telling them they have to do it. it's kind of something that I have seen start to change, but that assumes that the executives understand that they are potentially liable for security failures. So, losing my voice, which is good timing because I'm just about done. What about other questions, discussion, etc.?
Jake, I just wanted to mention that that is a great point, and I utilize that a lot at Mod Pizza with the legal department. I was really worked really closely with them, and they would champion security causes, and I think that you're right. It's a good strategy to have their voices on your side when you're dealing with
Yep.
executives.
I do want to talk about this because the attorney-client privilege. This is a perfect example of how a few years ago I spotted this and I talked about it all over the place. And quite honestly, I think my audiences found it interesting, but nothing was really happening in the courts. Well, that's all changed. In the last literally 6 months, you've got multiple federal courts and circuit courts of appeals, which for those not up on their civil procedure is one step below the Supreme Court, that have taken up this particular issue. And I think a really good one to look at is the Capital One data breach litigation. They basically found that the way that Capital One hired Mandiant and the way that their lawyers interacted with Mandiant and what they did with what was done with Mandiant's report rendered the report not privileged. So a lot of lawyers have been scrambling and running around in the last couple of months trying to figure out, crap, how do we keep security reports and forensic information privileged? And there are ways of doing it. But right now it's much more up in the air than it used to be, which makes it even more important to kind of be aware of. One of the main things that you should remind your own companies is that if they need to investigate a breach, do not let the business unit hire the company, the security consultants. It actually needs to be paid out of the legal budget. And that sounds crazy. Better yet, actually, is have outside counsel hire the security consultant and don't even have a contract with them. This is, I mean, talk about like up to the minute kind of information. This is just really, it's all happening in real time. Doesn't
that mean that you can apply legal hold? The enterprise can apply legal hold, right?
Well, so a legal hold is rather different. A legal hold is a way to avoid having evidence spoliated, which means deleted, and then you don't want that to happen because the court will just basically assume that what the other side was looking for is true. So legal holds are critical, but this is different. This is specifically about how to protect using attorney-client privilege and attorney work product the results of forensic reports and security consulting in the aftermath of a breach. So
aren't discoverable, right? They're made not as discoverable from the other side.
Right. The question is whether they're discoverable. And what we've learned is that unless you do it exactly right, they are discoverable, which is horrifying, or should be.
Extremely horrifying.
Yeah, no, I mean, I was on, like I said, I was with the Sedona this past 2 days, and we were all sitting around scratching our heads trying to figure out what exactly does the court want us to do. And there's a bunch of them. I should probably, maybe I'll send out an email with them. But if you really just if you just Google Capital One, a work product, I guarantee you'll find an article or 10 on this. And I believe there was an update yesterday with only the transcript of the hearing was available, which means that it had just happened. And that's the fun part about it, is that in this different situation where PwC was hired, there was privilege and it was work product and it was protected. That was because the Capital One had hired them specifically to investigate the breach, whereas Mandiant had been kind of on retainer, and they had also been used for proactive security consulting. So, I mean, I guess what can I say? I'm sorry, but the lawyers are now invading your space, and there's going to be a lot of pain and suffering until it gets figured out.
Work with the
Hey,
lawyer to get
that
defensible due diligence.
I'll let everybody continue the conversation. I wanted to give everybody opportunity, since we are at the top of the hour, to leave. Thank you very much for your attendance. I also wanted to close down the recording at this time, just again to keep the precedence of this meeting in place. So, Jake, maybe you could hit the record. Please keep in mind that